Welcome to the Appellate Division First Department. We have more than 5.5 hours of argument time requested, so only ask for the time that you need, not the time that you want. We are familiar with the briefs and the records, and if we have further questions, we will keep asking them. People versus Galloway. Appellant? Respondent? 5, 1, and 5. Pierre versus City of New York. Appellant? It is submitted. Artist versus Stephanie is submitted. Betancourt versus Arc. Appellant?
4 and 1.
Respondent?
4 and 1.
You don't have a cross appeal, do you? 4, 1, and 4.
4
Kosachuk versus 9197. There are 2 different cases on the docket. They will be argued together. So the time you get will be for both of the cases. Appellant?
10 and 5, please.
Respondent? 5 and 1 for appellant, 5 for respondent. People versus Hernandez. Appellant? Respondent? 4, 2, and 4. Camatini versus Extell West 57th. Appellant?
6 and 2, please.
Respondent?
Respondent 6, please.
6, 1, and 6. Irvine versus City of New York. Appellant?
Appellant 10 and 5, please.
Respondent? 6, 1, and 6. People versus Ortiz. Appellant?
Appellant request 6 and 1, Your Honor.
Respondent? 6, 1, and 6. Pepin versus Lascano. Appellant?
Appellant, Your Honor, 3 minutes.
And do you want any rebuttal time?
No.
Okay, 3 minutes. All 3 respondents here? Okay.
Yes.
Why don't we do Lascano?
Lascano request 5 minutes.
Okay. Bello?
3.
And Franchini? Okay, 3 and 5 and 3 and 2. 2497 Realty versus Fortress. Appellant?
6 and 3, Your Honor.
Respondent?
5, please.
6, 2, and 5. Jenkins versus Gina B. Appellant? Respondent? 7, 1, and 7. People versus Ross Campbell is submitted. Marson versus 4 West 16th Street is submitted. Guerra versus Munoz is submitted. Duncan versus United Capital is submitted. So the first case is People versus Galloway.
May I proceed?
Go ahead.
Good afternoon, and may it please the court, Nicole Giuglas on behalf of appellant Antoine Galloway. At the time of his offense, 19-year-old Antoine Galloway was living in an overcrowded, under-resourced apartment beset by violence. He'd lived there in the same home his entire life, alongside caregivers.
Counsel, we're familiar with the record. One of the requirements under this act is that you show a temporal nexus between the abuse and the offense. How would you establish that nexus in this case where it's undisputed that the abuse was not ongoing at the time of offense and in fact had stopped 4 years before he committed the offense?
So it is not undisputed that the abuse was not ongoing at the time of the offense. There was not instances of physical violence.
I'm sorry, the physical abuse stopped.
Yes, the physical violence, one form of domestic violence, had not recurred in the months and years.
So what
immediately.
evidence do you actually have as to abuse within the year of when this incident occurred?
Mr. Galloway was still living in the same home with an ongoing abusive relationship. An expert testified to the ongoing psychological abuse that the
Wait, but
same...
Not What was the actual abuse he was suffering at the time of the incident? And what evidence is there in the record of that?
The psychological abuse consisted of acts of omission, including the deprivation of of necessities, including food, clothing, and other things that an individual needs to survive.
And what evidence was there in the record to support that?
The evidence supporting that were the affidavits that were offered from both Mr. Galloway as well as his sister and his sister-in-law who witnessed these events, as well as the testimony of an expert qualified who had examined Mr. Galloway and examined the record and testified to the instances of ongoing abuse that Mr. Galloway was experiencing up to and including the time of the instant offense.
What was the connection between the alleged abuse and the incident that occurred in this case? Because normally in actions, in these cases, there's some connection between the abuse and the alleged incident. What is the connection in this case?
Here, the connection between the ongoing domestic violence and the crime, which was a robbery, is obvious in the sense that the record established that after being subjected to years of physical violence, deprived of basic necessities, and taught by those around him to take what you need by force, the link to his ultimately committing a robbery was plain to see. The expert also testified regarding other contributing factors that made clear that the offense, that the violence was a significant contributing factor.
Counsel, wasn't the sponsor's memorandum to this act stated that the bill was meant to address the unjust ways in which the criminal justice system responds to and punishes domestic violence survivors who act to protect themselves from an abuser's violence? So there was some type of limitation, not complete limitation, but that was sort of the main focus of it. And the arrest was for something completely unrelated to the abusers, to the abuser, or anything relating to the abuser's violence. And that was another concern I had in addition to the temporal issue.
That was one of the motivating factors for the legislation, but specifically in creating such a broad and remedial statute, the drafters and the legislature that enacted the DVSJA removed any need for justification or a limitation to only cases where the either the abuser was involved in the offense or was a victim of the offense. It intentionally is broadened to include offenses that have third parties involved. And many clients, many individuals have been granted relief with that understanding. In fact, the people cite certain cases even where that relief, where the individual committed, in one of the cases, in People versus DL, relief was granted to a individual who had, as a result of a significant substance abuse issue that was linked to the substantial abuse that they suffered, had committed a burglary.
Thank you. You'll have time for rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Jennifer Mitchell for the People. The motion court correctly denied defendant's motion for resentencing under the DVSJA. Defendant has failed to make the three-part showing necessary in order to obtain resentencing in this case. First of all, defendant was not a victim of substantial abuse at the time he committed the instant offense. Defendant was 19 at the time of the armed robbery. And there is no question here that defendant was a victim of domestic violence during his childhood. But the physical violence against him had stopped by the time he was 15 years old.
What about the other abuse that was alleged, so deprivation of being fed and having sufficient food, and the continuing effects of the abuse he suffered when he was younger?
To your first point, Your Honor, about the deprivation, there simply just wasn't enough evidence presented regarding that to reach the level of substantial abuse required by the statute. And as to the long-term effects of any of the physical violence that occurred, that type of psychological abuse, or that psychological impact is not what was anticipated when this statute was enacted in terms of substantial abuse at the time of the offense. Defendant just has not met that standard here. And then even if he had, Your Honors, the second point is that there is simply no link between the abuse defendant suffered being a significant contributing factor to his commission of the armed robbery in this case.
What is the requirement exactly for what type of connection you have to show between the abuse and the act?
So there needs to be some type of inextricable link between the abuse and the crime committed. And while the DVSJA did broaden that scope slightly in order to, so that it no longer has to be necessarily against the abuser themselves, there still needs to be some type of connection between the two, and that's simply not present here. The armed robbery was committed with two accomplices, neither of which there's any evidence suffered the same type of abuse that defendant did, and it was an armed robbery of a local grocery store against two random citizens of defendant's community. The abuse he suffered within his family home had absolutely nothing to do with his actions in this crime. And so he has failed to meet that link standard here. And in addition, Your Honors, defendant's own expert had testified that there was no reason to believe that domestic violence was on defendant's mind at the time he engaged in this criminal behavior. And so that alone, he fails to meet the second prong. And then finally, Your Honors, defendant's sentence was not unduly harsh in this case. This court has already upheld the appropriateness of defendant's sentence on his direct appeal. And in any event, the egregiousness of this crime warrants the sentence that he received. If there are no further questions, we ask that you affirm.
Thank you very much.
Thank you.
Nowhere in the statute do the words inextricable link appear. There is no requirement under the DVSJA that there be an inextricable link between the abuse and the offense. The standard is significant contributing factor. And here, an expert who examined the entire record testified not that, yes, he testified that it wasn't on his mind at the time of the offense, but there were multiple other factors that indicated that the abuse that Mr. Galloway experienced was a significant contributing factor to his offense. Moreover, the idea that the long-term impact of ongoing years of abuse is not intended to be captured by the statute is
Don't we specifically have a case from the First Department requiring the temporal proximity, that's an established element of what needs to be shown?
an established element of ongoing abuse or abusive relationship. Mr. Galloway was still in an abusive relationship. He was still experiencing ongoing abuse.
Thank you. Bettencourt versus Ark.
Morning, Your Honors. My name is Lester Channon from Farber, Brox & Zane. I'm here on behalf of Open Kitchen, which is a restaurant that used to be located in the Wall Street area downtown. It was a busy coffee shop deli that many of the workers would run into to pick up their morning coffee or a donut or something. And on this particular day, as the video shows and as the testimony reflects, the plaintiff was doing what he typically did, which was to stop off for a cup of coffee. And he opened the outer door to the restaurant, and there was a mat there that fully spanned the vestibule area there. And he took a partial step onto the mat and then a full step on the mat. He failed to wipe his feet, and then he took one additional step
What's your position as to the interplay between the storm in progress doctrine, which is what you're relying on, and the requirement that there be regular inspections of the premises?
There's a rule that I think is, well, that is been found to be in effect by this court many, many times in many of the cases we cited. The rule is that you don't have to cover the whole floor with mats, and you don't have to continually mop up, okay? So what you have is a situation where it's the morning rush, people are coming in.
And it was raining at the time. I mean, I think we all had the opportunity to see the video, and everybody was walking in with umbrellas, and it was dripping all over.
So how could, like, if you don't have an obligation to continually mop, right, then what is the point of an inspection? Right? In other words, he didn't see it. He admitted he didn't see it. It wasn't visible upon his entry. Afterwards, he said there seemed to be some sort of a gloss, but he admitted there was no puddle. So you have a little bit of moisture on the floor, which is unavoidable, which the Court of Appeals held in that lovely case, Miller versus Gimbel Brothers, where they're walking into Gimbel's, the plaintiff, and it was a slanted marble area in the vestibule before you get to the revolving doors, and it was a slip and fall. The court said, yes, there was some water on the floor, there was a little mud in the revolving door. This is 1933, but the court said it's virtually impossible to make it completely, moisture-free. So it was not considered to be a dangerous condition, and the New York, this court has held many, many times that the tracked-in water in and of itself is not a dangerous condition. Here, there was not visible to the plaintiff, which this court has held multiple times, it demonstrates that there was no constructive notice. The plaintiff admitted that he didn't know how long it had been there. He didn't know how it got there. He couldn't dispute that it had been tracked in by the people who walked in 30 seconds before him and a minute before that, and so on. That morning, it had just opened up at 7 o'clock. The accident, the plaintiff said, happened sometime between 7:30 and 8:15. But even if they had been inspecting, they didn't have an obligation to keep every customer that came in and dripped his umbrella or his galoshes onto the floor. They didn't have an obligation to keep cleaning up after them. And so even he admitted that his own sneakers were wet. So he obviously tracked in some of the moisture himself. He admitted didn't admit he failed to wipe his feet off. He thought he had, but the video reflects otherwise. And so this is a situation where the restaurant did all they could. There was a wide mat in the opening and then multiple others.
Your Honor, good morning, good afternoon. I'm Anthony Rodriguez on behalf of the respondent. The court below properly denied summary judgment on the issue of constructive notice based on the Topchiva case and also based on a long history of law that says to establish a lack of constructive notice, you must prove adherence to specific maintenance policies on the day of the incident and what the condition was in the last inspection.
What about the storm in progress doctrine? Under the storm in progress doctrine, isn't there not a requirement that you have to keep doing inspections as the storm is progressing?
No, the storm in progress doctrine starts the inquiry, doesn't end the inquiry.
Right, but if you can show that there's a storm in progress and water was getting tracked in as a result of that storm in progress, doesn't that relieve you of your burden to show the continuous inspections that would normally be required?
No, it
or
doesn't.
Inspections generally.
No, in both the Pohamet case and the Topchiva case, both involved rainstorms in progress. What they said was the analysis, it should be all of the circumstances regarding a defendant's maintenance efforts must be scrutinized in ascertaining whether the defendant exercised reasonable care in remedying a dangerous condition.
So what was unreasonable in this case? It's undisputed that there was a mat at the door, and there were various mats throughout
The mat did not cover the area of ingress and egress. It left an opening, a wet, bare floor at the place of ingress and egress. It only
You mean
had one mat.
past where he walked in?
He walked in through the front door, and
Right, and there was a mat there.
there was one mat, and then he took a second step onto the bare, wet floor and slipped and fell.
But is your position then that the mat has to be continuous throughout the entrance to, all the way up to the counter?
There should have been a question of fact that, there should be a question of fact as to whether there was a negligent placement of the mat. That's what the Topchiva case stood for. No storm in progress was, the case was not denied because of storm in progress, and it granted,
Well, wasn't there a distinction in that case, because there the plaintiff was entering into her residential building, and there was a locked door, and there was a mat on one side but not on another. They unlocked the door and she walked in where there was no mat at all. Here there was a mat, but if I'm understanding what you're saying is there shouldn't have been any space between that first mat and the second mat, and I think that's where he fell.
well, there's a question of fact as to whether they had constructive notice. That's what the motion was on constructive notice and Topchiva. On constructive notice, the cases are clear. They have to show prior inspections, and they have to show, it doesn't relieve them, storm project does not relieve them of the entire inquiry of what was reasonable under the circumstances.
But would that be sort of absurd to impose on them the duty to inspect, but then under the storm in progress rule, they'd be obviated or relieved of any duty to provide a continuous remedy?
There's
So
no-
what point would the inspection serve under the storm in progress rule?
Well, the inspections go to the constructive notice, and that was what the motion was decided on, constructive notice. She denied constructive notice. She said they did not have, did not prove lack of constructive notice. And the testimony was there were no inspections, and there was no testimony about adherence to specific policies and procedures on the daily incident. All of the testimony was absent. They could not remember, they didn't know any policies and procedures. That creates a question of fact on negligent placement of the mat based on Topchiva, and it also creates a question of fact as to whether they had constructive notice based on the lack of inspections and the lack of adherence to specific policies and procedures.
Now, how is this case distinguishable from Pomahawk then?
Which case, I'm sorry?
From Pomahawk?
Pomahawk. In Pomahawk, it was another tracked in rain case, but summary judgment was granted because coffee was spilled just a few moments before the fall, and at the time of the fall, someone was mopping at the same time. But in that case, they specifically said, in Pomahawk, they said, the nature of the inquiry is as follows. All of the circumstances regarding the defendant's maintenance efforts must be scrutinized and ascertaining whether the defendant exercised reasonable care in remedying a dangerous condition. A cracked in rainwater case.
Thank you.
Thank you.
Thank you very much.
So in Pomahawk, there were two pertinent rules that the court established or followed. One was the reasonable care standard does not require a defendant to cover all the floors with mats to prevent a person from falling on tracked in moisture. And secondly, nor does it require a defendant to place a particular number of mats in particular places. So while the Topchiva case seemed to perhaps say otherwise, it was sort of a unique factual scenario where, as Your Honor had pointed out, one door was locked, and there was at least an allegation that the mat was in front of that door, which was then rendering it entirely useless to everyone who was entering. And so we believe that that case, it supports our position. But
And if I may really quickly, and that's not what we have here, because the videos as well as the photos show initially there is a mat right after the external door, then you have that runner.
Exactly.
Right, and the plaintiff even indicated he didn't know how long the water had been there and acknowledged that mats were in place.
yes, yeah, that is the scenario. And then, and even he took a photograph afterwards within several minutes, I don't know exactly, but he admitted at deposition that it didn't even show any water, or that he couldn't see anything in the photo.
Thank you. Thank you very much.
Thank you, Your Honors.
Kosachuk versus 9197.
Good afternoon. I'm Chris Kosachuk here. I'm the pro se appellant petitioner.
Go ahead.
The judgment by confession at issue is void on its face as a matter of law because it was entered without jurisdiction, personal jurisdiction, over defendant NLG LLC, a Delaware limited liability company with no nexus to New York, no office in New York, conducting no business in New York, simply does not have anything to do with New York. Number two, the judgment by confession was collusive on its face because the plaintiff's manager, Raymond Houle, executed the affidavit of confession pretending to be the manager of defendant NLG LLC. This is in the judgment itself, which is in the record. The affidavit of confession is 29, and you can see it at the bottom. It says Raymond Houle, manager 9197-5904 Quebec Inc., manager NLG LLC. So on its face, this judgment is collusive. And this is specifically what the statute 3218 is designed to prevent, collusive judgments, because they defraud third parties, innocent third parties like myself. I'm a creditor of NLG LLC, and I've lost over $10 million pursuant to this sham judgment by confession that continues to stay on the books. This court needs to vacate, strike, and set aside this judgment to its date of entry, which is February 22nd, 2012, because it will continue to be used and is currently being used down in Florida to thwart my rights and my collection of money owed to me by NLG LLC. And I would like to point out, finally, that the judgment by confession statute, going back to 1873, this court said in the case of Burkham v. Van Son that the judgment by confession statute allows no confession of judgment on a tort. This judgment was entered on the tort of fraud and abusive process. It is clear on its face. That's what the judgment itself says. Additionally, Mr. Houle used an address for his own attorney, 6499 Powerline Road down in Fort Lauderdale, Florida, which is his own attorney, Arthur R. Rosenberg, who coincidentally is an attorney admitted to practice here in New York. His bar ID number is 170992, I believe. But he is registered, and I actually checked his registration status, and this Powerline address that they list for the defendant NLG is still listed with this court as Mr. Rosenberg's address, who is the attorney of record for Quebec. And when I say Quebec, I'm referring to this company 9197-5904 Quebec Inc. Now, Quebec, as it stands right now, is my judgment debtor. Quebec and its principal, Mr. Houle, along with their attorney, Mr. Marzak, filed a bad faith involuntary bankruptcy against me in the Eastern District of Pennsylvania. Judge Fitzsimon found the petition so offensive that she dismissed it, sealed the record, and awarded me $1.2 million against Quebec, which is wholly unsatisfied. As for the second part of this, the second appeal that's pending is the issue that the trial court awarded $15,000 in sanctions against me for bringing this petition to challenge a void judgment. That needs to be reversed as well. Thank you.
Thank you very much.
Good afternoon. I'm Barton Sobel, attorney of record for the respondent. It's my pleasure to present Todd Moser, who will be arguing by leave of the court.
Thank you. Good afternoon, Your Honors. My name is Todd Moser. I've been admitted pro hac vice. I'm from Pennsylvania. With all due respect to Mr. Kosachuk, he didn't talk anything about what happened in this case and why we're here, what we're here to review. The arguments he just made have been made before and rejected numerous times, court after court after court after court, and consequently, when he tried it again this time, he was sanctioned $15,000. The bottom line here is the law of the case is that Mr. Kosachuk's claims are time barred. Judge Billings below explained why. To get straight to the point, Mr. Kosachuk had litigation pending in state court in front of Judge Hagler in 2019, seeking to make all these same arguments he's trying to make now. He withdrew that litigation after he had tried to make the same arguments in 2014 and abandoned that then. So in 2019, he's making the same arguments he's making now. He withdraws all that litigation in state court, brings a plenary action in federal court. District Judge Croat holds, among other things, that he's time barred. The Second Circuit affirms that. Then Mr. Kosachuk went back before Judge Hagler, and Judge Hagler said, I agree with District Judge Crow. This is completely time barred. Mr. Kosachuk appealed and then abandoned the appeal. So at this point, where we're at is the law of the case is his claims are time barred. And you know, he can try to attack the underlying judgment as much as he wants, but this is an error correcting court, and the issues in front of this court are not what he actually, what was at issue below. What's at issue below is whether he's time barred. And the other holding that the judge below made, which he completely fails to mention in his briefing or in his argument anywhere, is that 4 days before he instituted this litigation, he did the same thing in Delaware. So he had something pending in Delaware before he did the same thing here. So 26 different ways to Sunday, this case was properly dismissed. It's time barred, it's res judicata, it's law of the case. And with all due respect, this is why $15,000 in sanctions was awarded below, why that's completely appropriate. This has been going on and on and on. Same arguments year after year after year being rejected all the time. And it's untimely. And, you know, I don't know what he's going to say about that. I've read his brief, but his arguments have been specifically rejected before. So
Thank you.
This court has said that CPLR 5015A4 has no stated time limit and can be made at any time. This is the case of Caba v. Rye. So there is no time limit. And if there is a time limit on challenging a void judgment by confession, I am still timely, because on September 3rd of 2015, they declared this judgment satisfied, which should have stopped all proceedings. Unfortunately, they took this satisfied and void judgment down to Florida and used it to strip NLG of its $4.876 million final judgment of foreclosure. The debtor, NLG's debtor down there, Elizabeth Hazan, filed a bankruptcy. Then they filed an adversary proceeding, and they used the satisfied judgment by confession from this court and said, it's still outstanding. We're going to offset the $5 million that's owed against the 4.876, and we're going to find that there's still $123,000 due and owing. Judge Crystal down in Florida entered that order on November 1st of 2017. So if there is a 6-year statute of limitations, it's timely because this petition was filed in September of 2022.
Thank you. Thank you. People versus Hernandez.
May I proceed?
Yes.
Good afternoon, Your Honors. May it please the court, Rashad Moore on behalf of Mr. Hernandez. This court should grant Mr. Hernandez a downward departure because he has demonstrated that he is a low risk to the community. Offense-free time in the community is a mitigating factor that can justify a downward departure. Indeed, SOAR courts have noted that post-release conduct is the single greatest factor for determining whether an individual is a risk to the community. Here we have 4 years since Mr. Hernandez was arrested for the instant offense in which he has been in the community offense-free. This is in line with the expert who assessed him and said that, I quote, he has had the opportunity to reoffend and he has not done so. So by virtue, he is in that lower risk band. Further, there are other mitigating factors as well. Mr. Hernandez is supported by his family, who wrote glowing letters of him into the sentencing court. He's also supported by an age-appropriate intimate partner who is aware of the offense, and because of her influence, someone who once described themselves as spiritual but not religious, prays nightly for forgiveness and is saddened by his previous conduct.
I just want to go back for a second because you talked about the fact that the defendant has not committed any further offenses since, being released and now on post-release supervision. But, what about the fact that part of the PRS, right, you can't use cell phones, you can't use computers, and didn't the defendant engage in that activity? So is that really, persuasive that, that he's not committing any new crimes? Yes, because he's not using the computer, he's not using the cell phone.
It's yes, Your Honor. It's still persuasive because he could have done so, and this would have been a violation, and then he would have been incarcerated in federal prison. His decision to not do so demonstrates that he is interrogating his conduct, which is part of treatment and part of the voluntary therapy he's doing as well. And further, what Gelati asked for is a balancing, whether the mitigating factors outweigh the aggravating factors. And the sentencing court, the court most close to this, heard from the prosecution, heard from Mr. Hernandez himself, heard from all the parties, heard testimony from the doctor saying that he's a low risk, looked at Mr. Hernandez and said, I quote, "There's every indication that Mr. Hernandez is not only remorseful for his misconduct, but has moved on." And instead of sentencing him to 14 years in federal prison, and even the U.S. Department of Probation said that this court should deviate from the guidelines, instead of doing that, sentence him to time served.
Was there an issue about whether he had insight into his offenses, saying that he didn't know these girls were underage?
That quote was taken out of context. When you read the interview that Mr. Hernandez did with the Department of Probation, he stated that he knew his conduct was illegal at the time and that he was sorry for his conduct. So this court should look at what the federal sentencing court looked at and determine that he is a low risk to the community, because since then, since the arrest, he's been in the community without reoffense. He has developed an even stronger support system that's aware of the offense. He's engaged in treatment, and he has demonstrated that he is a low risk to the community. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Aiden Sanchez for the people. Your Honors, Judge Bruce did not abuse his discretion when he denied the defendant's application for a downward departure in this case. I'll just note that the defendant conceded that he was properly assessed 80 points, placing him squarely in the level 2 range. And all of the mitigation that defendant raises now was before the SORA court previously. Of course, the length of time has changed now, but this was all presented to Judge Bruce and considered by Judge Bruce when he made the decision to deny the downward departure application. I'll just remind, as this court knows, that SORA is not a punitive statute. It is a community notice statute, and the community deserves to know that the defendant about the defendant's conduct here. And the psychiatric evaluation that was done on the defendant, the doctor did note that although she did not evaluate him for pedophilic disorder, that he may meet the criteria for that disorder. And that's an important fact for the community to know. And a level 1 designation would not allow the community to know that the defendant is in fact or engaged in this conduct previously. And I'll also note that the defendant can in the future petition can petition to change his designation when he makes further strides into actually changing, making strides towards rehabilitating himself. For example, there's a discrepancy as to whether the doctor actually evaluated the defendant for pedophilic disorder in the record. That's something that the defendant can clear up. He can continue treatment. He can get an actual evaluation, and that can clear that discrepancy up. He can petition for a level change, and that would be the appropriate path forward. This defendant, the detail is in my brief, but I'll just note that the conduct that the defendant engaged in was egregious. He, over the course of a year, communicated with a 13-year-old girl, sexually abused her via video, recorded the video, saved them to his laptop, created his own pornography. And on top of that, he possessed 600 other images and videos depicting adults abusing children, some as young as toddlers. So unless the court has any questions, I will just rest on my brief.
Thank you.
Thank you.
So first, opposing counsel misstates the law. This court need not find that the SOAR court abused its discretion. It's an independent de novo review. So everything that was before the SOAR court is before this court, and this court need not find so. Secondly, the government in its brief and recently says that he may meet the criteria for pedophilia, but the doctor testified that she did not test him for such. But by the same logic, we can also say that Mr. Hernandez doesn't suffer from pedophilia because he is in an age-appropriate intimate relationship. That is not necessarily a discrepancy or something. That's just we're not experts in that field, and an expert decided not to test him for it, and we don't necessarily know the reason why, but he's demonstrated that he is moving forward with his life. The opposing counsel also discusses the contact nature of the offense, but what's very important here is that the federal sentencing court was aware of all of the aggravating factors in this case that were noted, but still saw fit to allow Mr. Hernandez to be in the community the entire time of the pendency of the case, and looked at him and said that this is a person who has moved on. He was assessed conservatively by the doctor, and that doctor then testified that he is a low risk to the community. And because the people most close to an individual, and one being an expert, this court should see that Mr. Hernandez in those 4 years has demonstrated that he is a low risk, and this court should grant a downward departure to level 1. Thank you.
Thank you very much. Caminiti versus Extel.
Good afternoon, Your Honors. May it please the court. Christopher Della Carpini for the appellant, Ms. Caminiti. CPLR 4513 could not be clearer. Evidence of a criminal conviction may be admitted to go to the weight of a witness's testimony. The statute doesn't say anything about divorce judgments. It doesn't say anything about administrative appeals. But that's what the defendants introduced in this case. Now, the defendants argued in their briefs that Dr. Levine was justifiably impeached with the New Jersey decision because he supposedly opened the door when he testified incorrectly that this trial was the first time he'd ever testified.
Let me ask you something. There's no question that it was proper to bring up his criminal conviction of conspiracy to defraud, even if there was some error in allowing the administrative determination or the divorce issue. Why isn't that harmless error? Particularly since his credibility had already been impugned by the proper admission of the criminal proceeding and by the fact that he did give an incorrect answer about whether he'd ever testified before.
I think if you look at the record on this at 602 and 602 for the New Jersey decision, you can see the harmful effect of this. They got exactly what they were entitled to get about the New Jersey decision. They asked Dr. Levine, didn't you in fact you said earlier that this was the first time you testified. Didn't you in fact testify previously in New Jersey? Dr. Levine immediately said, oh, yes, it was. Then they not only read from that decision into the record, and this is not a criminal conviction, this is a finding of a judge in a divorce proceeding, they displayed it to the jury. Now, my instinctive reaction to your question is—
acknowledging if there was error, how was it not harmless in terms of the context of the whole proceeding?
They've already established one incident that he was the incident of a lack of credibility, the criminal conviction. This is a completely unrelated incident. It has nothing to do with the criminal conviction, and it's not a criminal finding either. There's a reason only a criminal conviction is left. Yes.
What about his testimony that he didn't have hypertension when the medical records indicated that he did, his own medical records?
What his medical records indicate, as he testified, is that Mr. Caminiti had borderline hypertension that did not need to be managed, did not need to be medically treated. And that, getting into another one of our points, is a theory that we have held the whole time in this case. We've never denied that Mr. Caminiti had hypertension. We brought this out on direct. Both sides used Dr. Levine's records, and that's another point. This is so completely collateral because both sides relied on Dr. Levine's records. What does anything that happened in his divorce have to do with the extent of Mr. Caminiti's hypertension? My instinctive reaction to your initial question, Your Honor, is if it wasn't harmless error, defendants wouldn't have introduced it. They introduced this for the purpose of beating up on a witness on a completely unrelated matter that wasn't even criminal. It was a civil finding, a divorce finding. That's why I think you can't overlook this. And I would cite this court to the Rudel decision, which we cited in our reply papers, in which the exact same thing happened. The Second Department found that the trial court improperly allowed impeachment of the defendant with, I think they put it as, extrinsic documentary evidence concerning collateral matters. That is exactly what happened here. And the Rudel court cited the Court of Appeals in Mazzella, which I think really talks about why you can't look away from this error. The Mazzella decision said collateral matters relevant only to credibility are properly excluded because they distract the jury from the central issues in the case and bear the risk of prejudicing the jury based on character and reputation. We've got a textbook example of that here. We have a doctor whose records aren't disputed, who is smeared with these collateral matters.
Right, but he'd already been, quote, smeared by his criminal conviction and by certain discrepancies in his testimony. So that seems to be a higher degree of criminal conviction, which was proper. So that's the question in terms of the harmlessness analysis.
I think it's evident from, I think I would direct you to the record in the transcript to see how this played out at trial, to see how the defendants played up I don't recall they read from the criminal conviction, or any order in the criminal conviction. They read from the divorce decision. They really laid it on here.
Why wasn't the determination ultimately, the two experts testified to different things, and it was up to the jury to make that determination as to which expert was more credible in terms of the medical records. And in fact, that issue had been identified by this court in reversing the summary judgment, that was an issue for the jury to decide whether or not this incident on the ladder caused the injury.
I think you're making my point for me, Your Honor. This was a battle of the experts, and the defendants are coming in here smearing Dr. Levine with his divorce. All the more reason why that's inappropriate and why I think you can't overlook that. If I could address the other errors we found in there, there was also the error of the failure to instruct the jury on increased susceptibility. Now, I admit, we did not use the magic words increased susceptibility at any point in this case, but it's been our theory from the Bill of Particulars. We pleaded that to the extent that the defendants claim a pre-existing condition, we claim it was activated or exacerbated.
So wasn't your position at trial, as opposed to the Bill of Particulars, that he was perfectly healthy and he did not have hypertension, and no hypertension had anything to do with this incident? So isn't that inconsistent with this jury charge?
I don't think so. Again, we brought out on direct with Dr. Levine that Mr. Caminiti had borderline hypertension. We also brought out with Dr. Levine that it did not need to be managed. It was not a concern. There was not the constellation of risk factors that
Wasn't
Dr.
there a
Argosiano
clear
found.
position at trial, though, that he was healthy? There's nothing wrong with him. Wasn't that the position that was actually taken at trial?
We certainly brought out borderline hypertension, but we also brought out that it didn't need to be treated. In that sense, he was fine. He was healthy until he faces the stress of trying to keep from falling off this unsecured ladder, a labor law violation that the jury found.
Thank you. Thank you.
Thank you, Your Honor.
Time rebuttal.
Good afternoon, Your Honors. May it please the court, my name is Scott Haworth. I'm here on behalf of the respondents.
Counsel, what about the fact that things came in that might have been improper in terms of the further credibility attack? And
I assume Your Honor's talking about the divorce?
The administrative proceeding in the divorce.
Okay, well, with respect to the divorce, very first question from Mr. Canavo at trial was, have you ever testified before? I know from the Appellate Division decision, and only from the Appellate Division decision, that in fact he has. And then there was a judicial finding by the Appellate Division that in that testimony he lacked candor. That's as far as it went. We didn't talk about the divorce. If Your Honors read the decision.
Didn't you put in some of the papers and show them to the jury?
No. No. What we did was I used an overhead projector and I read that one paragraph and that one paragraph only. It came right off the overhead projector and that was it. We did not talk about.
That is sort of showing it to the jury if it's on an overhead projector.
They couldn't read the whole page. The decision itself, if Your Honors read it, is not good for the doctor. It talks all about child support issues that are unsavory and whatever else. We didn't talk about the divorce. We didn't talk about any of that. It just happened to be a divorce decision. That's the end of the divorce decision. With respect to the administrative proceeding, all the time in cases out of the first department, second department, and other departments as well, administrative proceedings are used with respect to doctors to impeach their credibility, with respect to licensure issues, fraud issues. There was one case out of the first department where a chiropractor had claimed that in school he had seen patients when he hadn't. Things like that go directly to credibility. The Mazzella case is not a per se case against using administrative proceedings. Rather, in that case, the plaintiff tried to use the consent order from the administrative proceeding as to 12 other patients to say, well, if the defendant doctor did as to these 12, he also did as to this one, who was the 13th. And with respect to the 13th and the consent order, the doctor had specifically reserved his right to defend himself as to that 13th. It had nothing whatsoever to do with what we're dealing here, where it's an administrative decision by an administrative law judge bearing directly on the fraud conviction. And we already know that the fraud conviction was admissible, clearly. With respect to Dr. Levine's substantive testimony, aside from the opening statement, Your Honors asked about the hypertension. Now, he says, did he ever have what you consider to be hypertension? The answer is no. During the entire 10-year period you treated him, did he have hypertension? Answer, no. In your opinion, to a reasonable degree of medical certainty, did he have hypertension? Answer, no. And then Mr. Canavo says, and it wasn't hypertension at all, was it? He says no. He then
Well, is there a difference between hypertension and borderline hypertension?
There was testimony that there's no such thing as borderline hypertension. While Dr. Levine said it's borderline hypertension, he said half a dozen different times it wasn't hypertension at all, that the man had nothing wrong with him, and therefore reasons and gives an opinion, and a very clear opinion, that the sole reason this normal, healthy man sustained the dissection was because of the alleged latter incident, that is the 245
So what counsel said before about talking about an exacerbation of a situation, that was put into the bill of particulars, that's not really how the case was tried?
That's not how it was tried at all, Your Honor. From the very beginning, from opening statements forward, Mr. Canavo said in opening statement, he didn't have hypertension. You can hear all about hypertension. He said hypertension, hypertension, hypertension. You're going to hear all about it. It's all bunk, essentially. He then put Mrs. Caminiti on the stand and asked her flat out at the beginning, did he have hypertension? Did he have anything wrong with him? Answer, no. He put Dr. Dector on the stand, who said the same thing. He puts Levine on the stand, who says the same thing. He doesn't put up a single witness who says this poor man had a susceptibility to a dissection and they had him working in the freezing cold on an unstable ladder. Had he said that, it would have been different, but that wasn't his theory of this case at all.
Sir,
His theory was there's nothing wrong with
at
him.
all that your expert cardiothoracic surgeon indicated that as his death was caused, the aortic rupture was caused by a constellation of factors, including his history of hypertension? Was that a sufficient factual predicate to warrant that charge?
No, not at all, because what Dr. Argenziano said and what Dr. Dector's literature actually said, and I cross-examined him at length on it, and that's in the record too, they both said that if the man had a 5.5 to 6 millimeter aorta, which we know he did because only Dr. Argenziano read the CT, Dr. Dector said that's a one-way ticket to the surgeon. Why is it a one-way ticket to the surgeon? It's a one-way ticket to the surgeon because whether you're sitting, standing, he said on the toilet, whether you're doing anything at all, you're at risk essentially for your aorta to explode. And it doesn't have anything whatsoever to do with what you're doing. That is replete through the literature that I cross-examined Dr. Dector on.
You were the trial attorney, right?
I was, Your Honor. And it's replete in Dr. Argenziano's testimony.
Thank you.
Thank you very much, Your Honors.
Turning to Dr. Argenziano's testimony, I just want to point out in the record, when he talked about the constellation of risk factors, he then on cross-examination had to admit that in neither of the reports that he'd prepared in the case did he ever mention atherosclerosis at all, nor did he ever give a measurement of Mr. Caminiti's aorta before dissection, and that's in the record at 760 and 807. He also had to admit that there was no evidence that Mr. Caminiti had left ventricular hypertrophy, which is a symptom of long-term hypertension, and that's in the record at 791 to 92. This would get to our fourth point in our appeal, that this verdict was contrary to the weight of the evidence. The only way you get to finding a labor law violation but no proximate cause is believing Dr. Argenziano. And as the transcript I cited shows, there was no basis for his conclusion about the constellation of risk factors just happening to cause this aortic dissection as Mr. Caminiti is struggling to keep himself from falling off this unsecured ladder. Are there any questions?
Thank you.
Thank you, Your Honors.
Irvine versus City of New York.
May it please the court. Good afternoon. Stuart Mermelstein of Herman Law for the appellant Lisa Irvine. CPLR 1024 has two requirements for adding an unknown party as a DOE defendant in a case. The first element of which is due diligence under the circumstances to identify the proper parties prior to the running of the statute of limitations. In this case, that due diligence element is readily satisfied by the fact that prior to the running of the statute of limitations, plaintiff made a demand for her foster care records pursuant to the social services law, which entitles her to a full panoply of records relating to her history in foster care. She made that request in July of 2021. It wasn't until there was a response the following March of 22, that there was any indication that plaintiff had sued the incorrect.
So you found out in around March 16th, 2022, right? That there might be an issue, that one of those John Does maybe should be the City of New York, is that right?
Yes, and it's important to note that the email between counsel on March 16, 2022 was equivocal. It didn't come out with
The thing is, it appears from the record, unless I saw it wrong, that you didn't move for another 2 months until May of 2022, when the statute had already run, to actually seek leave to bring in the city. So how was that not too late?
First of all, let me make clear that I think it's very, very dubious that the statute ran in March of 2022. There's the MC versus State case, which said that the statute would have run, and we're talking about the window of the Child Victims Act here,
I understand.
which, according to the statute, expired in August of 2021.
Right,
But then
but
you
it was
have-
extended because of the COVID, right?
Yeah, and it's unclear as to how the COVID extension applies.
You're arguing that it
Statute.
extended beyond March of 2022? And if so, what's the
No,
basis
no,
for
that would be
argument?
the outside
That's
date.
the outside. So you,
what
what
I'm-
my
what I'm
colleague
saying is-
asked was, you clearly knew before the statute of limitation expired, you got information, or someone got information, that the city was the right defendant, yet no one moved within that undisputed period. So again, how could that be timely, where it's undisputed that the information was there and nothing happened?
It was the understanding that the statute of limitations had already expired, and there was case law on that. I mean, the statute ran technically on August 14th of 2021. There's a COVID extension that was determined to be 90 days, and because this is combining the COVID.
So your argument, because you weren't sure if the statute of limitations had expired, it was okay to wait for 2 months?
There wasn't apparent at the time that there was an argument to extend the statutes to March 2022. So it appeared that we're relying on 1024 at the time that this information is provided in March of 2022. And I'll also note that the information was equivocal. There was no affidavit provided by Orange County. There was no evidence. There was no documents provided. They said, I'll read you the email. It says, it does appear that she was a New York City resident. It looks like she was likely in New York City's foster system. Apparently,
What
New York
efforts
City
did the
contract. So she
investigator
didn't know
make-
for sure.
What efforts did the investigator make even earlier on? Because the burden obviously was on the plaintiff. The plaintiff could have done pre-action discovery. The plaintiff could have done FOIL requests. There were many steps that plaintiffs can take to find out information at the beginning of a case to ascertain what steps were taken in this case on the plaintiff's part to ascertain who really was the correct defendant.
A couple of important points. The records that were requested back in July of 2021 would be determinative records. That she made a request for her foster care records. That would have told her who was responsible for her care in foster care. And I'll also note that the circumstances here were extremely atypical and unusual. She's being placed by the city of as it turned out, by the city of New York in a non-contiguous county, in a private foster home, not in a group home, not with a well-known foster care agency that was in the normal rotation by the city of New York. So this was like a surprise. It was completely unexpected. And when she found out in March of 2022, it was believed that the statute had already expired.
I like to go back to the investigator. So the investigator first speaks with the plaintiff, I believe, in May of 2021.
2021, right.
All right, so the question is, what, if anything, did the investigator do from May 2021 until 5 months after, when the investigator again spoke with the plaintiff? During that 5-month window, what, if anything, did the investigator do?
Well, within that window, the foster care records were requested. And you have to keep in mind here that based on the investigation that was conducted, every appearance had been that the plaintiff was in the custody of Orange County. That's based on the interview that was provided. That was based on the fact that the Orange County moved to dismiss on 3211A7 grounds, on substantive grounds of failure to state a claim. There was no attempt to say, hey, we don't think we're the right defendant. That didn't come out until, again, the following March, when it was believed that the statute had run and expired.
Okay, thank you very much. You'll have time for rebuttal.
Good afternoon, Your Honors. May it please the Court. Amy McCampbell on behalf of the City of New York. Your Honors, this Court should affirm the dismissal of the complaint because it's time barred. I see plaintiff spent all his time talking about CPLR 1024. This Court needn't even reach CPLR 1024 because the plaintiff has never argued relation back, which we would need to show to add a time-barred claim against the city. And this Court's decision in Higgins makes very clear that the Court need not even consider the applicability of CPLR 1024 if relation back is not met.
Does the decision actually say that, though?
It does, Your Honor.
I mean, it does it, but does it actually discuss it or talk about it or have an analysis about that issue?
It says that this Court need not, where defendant's argument concerning the relation back doctrine has merit, it's unnecessary to consider CPLR 1024. I would also point this Court to the Green versus County of Fulton case from the 3rd Department that says that CPLR 1024 does not toll the statute of limitations. Weinstein-Korn-Miller says the same thing, and both parties...
The thing is, nobody's really claiming in this case that there's a relation back, that the plaintiff has met the requirements of relation
Your
back.
Honor.
Not in this case,
Exactly.
because what relationship does Orange County have with the city of New York? So I don't think that's it. So if we were to reach 1024, and I appreciate what you're saying, is that still doesn't toll the statute. What could they have done? I mean, the statute ran apparently 2 weeks after they got the information that the city of New York might be the correct defendant.
Sure, Your Honor. So even if this Court were to reach CPLR 1024, which, again, it need not do, plaintiff has not met neither of the factors to apply CPLR 1024. Due diligence, I heard plaintiff just referring to one letter that she sent seeking social services records. She sent that letter after she filed the complaint, and there was no follow-up whatsoever. And we cited cases in our brief where you sort of limited discovery with no follow-up doesn't show due diligence. Plaintiff sat on her hands even after she got the information that she might be suing the incorrect defendant. And whether or not the statute of limitations had expired, I know plaintiff says it was a little unclear at that point. The Brook versus Pecana case says that if you know that someone might be a defendant and you don't take action, CPLR 1024 doesn't apply, and that's exactly the case here. And the second factor, Your Honor, there's no showing whatsoever that the city had any notice that it was an intended defendant here. This was a complaint that was filed in Orange County, served on Orange County, named Orange County as a defendant. The description of the Doe defendants in the complaint said that the Doe defendants were responsible for taking care of Orange County's foster care children through contracting. City doesn't do that. So there's no notice whatsoever. So neither CPLR factor is met.
And a little reference to Onondaga County just to
Exactly, Your Honor.
confuse the issue.
And I'd also just like to address the point that this situation was so unusual that the plaintiff would have had no reason to ever speculate that this could have been the case. The ER case, which plaintiff cites in their appellate brief, same attorneys, also a CVA case. That was also a case in which a city foster care child was placed in Washingtonville, outside of New York City. Again, same attorneys, filed in November 2019, a private house. So this was not so bizarre that no one could have imagined it. And if plaintiff had done the proper investigation and exercised proper due diligence earlier, then plaintiff would have had the opportunity to add the city as a defendant before the statute of limitations had expired. But the plaintiff did not do so. So for all these reasons, Your Honor, we ask this court to affirm.
Thank you very much.
Thank you.
I'd just like to make two important points here. I mean, the distinction that was missed by counsel is that this was a placement in a private foster home, not in New York City, but in Orange County, 70 miles away, which was unusual. I mean, in the respondent's brief, they talk about the cases that our firm, plaintiff's appellant's law firm, handles, that are also against the city of New York. And in none of those cases was there a placement in a private foster home. It's Children's Village, it's
Counsel, what about the relation back
other
doctrine?
facilities.
What about the relation back doctrine, that we don't even get to the analysis of the due diligence because Orange County is not united with New York County?
Yeah, there's two things. First of all, the case law, if you look at Tucker versus Lario, that's this court, 2002, there's a sequence of analysis there. It analyzes CPLR 1024 separately and distinctly from CPLR 203. That is the correct way to do the analysis. Our brief has a fairly extensive analysis, a statutory analysis, and the statutes make no sense if you superimpose on CPLR 1024 the elements of CPLR 203. An element of CPLR 203 is united in interest. That appears nowhere in CPLR 1024. You basically obliterate and write CPLR 1024 out of existence if you require a united in interest element. Basically, you're saying, well, you just have to comply with CPLR 203.
Thank you.
So, and that's against statutory constructs. Thank you very much.
Thank you. People versus Ortiz.
Good afternoon, Your Honor. May it please the court. Samuel Steinbach-Pratt from the Office of the Appellate Defender on behalf of Robert Ortiz. I'd like to begin by discussing the search. The court below correctly concluded that the officers strip searched Mr. Ortiz when they pulled his pants and underwear open, visually inspected his genital area, and reached inside to pull out a bag. But the court erred in holding that the search was nonetheless reasonable and therefore constitutional. The Court of Appeals in People v. Hall and this court in People v. Mitchell made clear that strip searches conducted in public are never reasonable except in cases of the most extreme exigency, such as cases posing a serious potential risk to the officers or others in the vicinity. No one has argued at any point in this case that any such exigency existed here, and it's clear from the record that no such exigency did exist.
Let me ask, isn't it undisputed that the officer did not actually pull his pants down in public?
So he pulls his pants forward, is what he says. I think that's a distinction without a difference because...
Isn't it very different to pull pants forward than to pull them down in terms of what's visible to the public?
So two things about that, Your Honor. I think, first of all, the analysis of strip searches has never turned on whether a member of the public, in fact, is able to see the private area. In fact, this court has talked about the part of the harm and the humiliation is even just the officer seeing it. And so it's undisputed.
Isn't one of the factors whether the genitals are exposed to public view?
I don't think so, Your Honor. I think it's whether the genitals are exposed at all in public. And I'll also note, it's not totally clear from the record that no one from the public could see what's going on. Mr. Ortiz is on the ground when his pants are pulled forward, so it's at least conceivable that a pedestrian would be able to see some of what's happening. But again, I don't think that's necessary.
Counsel, this was about 3 a.m. in the morning where many people were not out, and certainly defendant was not, he didn't disrobe. It appears that the detective, pulled forward and reached in and pulled out the bag that was on top of the private part. So how is that a strip search?
Yes, Your Honor. So just a couple responses to that. The first would be that the record makes clear from the surveillance footage that there are a significant number of people in cars passing by even at this late hour. The second thing is that, again, the cases don't turn on whether, in fact, members of the public are around. In fact, I've never seen that even really discussed in the case law. The question is just, is it in public rather than in a private area? And the third thing is that the key here, both as a matter of common sense and, the purpose of this rule is to prevent the humiliation and degradation that comes from having your genitals or other private areas exposed. That occurs even if it's just, the officers on a public street. And, I think the cases that are most on point are, that we cite in our brief, the Smith and Tisdale cases, material identical facts, pulling open pants and underwear, looking at the genital area, pulling out a bag. And the court in both those cases clearly found that a strip search had occurred because there was a visual inspection of the private area of the defendant's body. I'd also note that definition of a strip search, in addition to according with the case law and common sense, accords with the NYPD's own patrol guide, which describes a strip search as occurring any time that an individual's undergarments or private areas are exposed. That happened here, indisputably, under the NYPD's own standard, as the CCRB later found. So I don't think there can be any reasonable dispute that a strip search occurred here, and I would also just note that I don't really think it's properly before this court at this point because the court below found a strip search had occurred. And so under the LaFontaine doctrine, I don't think this court can affirm on a basis that was not decided adversely to Mr. Ortiz below. Because the strip search occurred in public, unless there was some sort of extreme exigency, which again, respondent has never argued and the record does not bear out, the search was unconstitutional and the evidence should have been suppressed. The detective, I would note, conceded that nothing prevented them from transporting Mr. Ortiz to the precinct before conducting the search. It was located only 2 blocks away, and he readily conceded that nothing stopped them from doing that. All of the, respondent makes a lot about the supposed concerns about destruction of evidence. That was, A, never part of the decision of the court below. B, is not borne out by Detective Lowe's own testimony. He never testifies to having any concern about Mr. Ortiz destroying evidence, or that was part of the reason for conducting the search. But C, even if that was part of the motivation for it would just plainly be insufficient under this court's decision in Missile and the People of Court's decision in Hall. Destruction of evidence has never been held to be sufficient. And I just finally like to note before I sit down that respondent has not cited, and I'm not aware of, any case in New York ever upholding the constitutionality of a public strip search. If the court did so here, it would be the first time to ever happen in the state. I don't think the court should break that ground. Thank you.
Good afternoon, Faith Petrolio for the people. May it please the court. To begin, the officer had a probable cause to arrest defendant. He saw defendant engage in a hand-to-hand drug transaction with another man. Defendant was let into the building specifically for this purpose. It was 3 o'clock in the morning. Defendant took cash from the other man, counted it, reached inside of his pants, and retrieved a small item, which he then passed to the other man before promptly leaving.
What's your response to the argument that the court below didn't find that it was not a strip search, so that we can't reach that issue?
Yes, Your Honor. I would argue that the court's decision below is slightly equivocal in terms of whether it decided a strip search actually occurred or not. It said, it acknowledged that, departments in the city sometimes find that under these facts is a strip search, but nonetheless, this is a reasonable one because it is so limited in scope. And I think the facts support that determination.
I'm sorry, say that, so you think that the court did make a finding that it wasn't a strip search?
I would argue that the court's decision is slightly equivocal. However, the facts contribute to a valid strip search. and also a valid search incident to arrest. So I would argue that the same facts that make it a reasonable strip search would also contribute to.
But based on the rule that we can't reach an issue that was not decided unfavorably against defendants, should we be reaching the issue then of whether or not it was not a strip search?
I would argue that you can reach the issue. The people did argue it below, and because of the court's decision below, it's not necessarily a different analytical framework, the search incident to arrest versus the strip search here.
What necessitated the strip search, or we'll call it the search? Certainly it involved, it was a very intimate search, whether it formally is characterized as a strip search or not. What necessitated the search occurring at the location of the arrest as opposed to at the precinct?
Yes, Your Honor. So one of the things the officer testifies to is that he will search a defendant based on his fear of destruction of evidence. And I think that was playing out in this case. While defendant was being pat down, he was leaning forward to attempt to stop the officers from finding what was inside of his pants. But also I think that creates a concern that the evidence would be destroyed.
How could it be destroyed?
Through his conduct, through bending forward. I think there is a possibility that, depending on, the officers weren't exactly sure what he was going to do with the.
But he was handcuffed at the time, right?
Yes, he was handcuffed.
And was he handcuffed behind his back?
I believe he was handcuffed behind his back.
So, and presumably he would have been transported to the station in that manner. So how could he have accessed his private area to potentially spoliate the contraband?
Well, Your Honor, like I said, he was leaning forward. He was fighting with the officers while they were patting him down. But I also want to add that the officers had reasonable suspicion to believe that he did have the drugs in his pants. The leaning forward was one of the things that contributed to that, but also the fact that the officer saw defendant reach into his pants. He was specific. He said not his pockets. He reached inside of his pants, and he placed the plastic bag. He took the plastic bag out and placed it back inside of his pants.
That would clearly justify the search. I guess the question is, where should that search have occurred? Is your friend correct that if we were to sustain the efficacy of this search, it would be the first time that an appellate court in New York has permitted a search of this nature in a public area?
I think the facts in Butler are very similar to this case. In that case, this court found that there was not a strip search because of the very, very minimal intrusion into the defendant's. It was exactly the same facts, reach into the pants. I believe the pants in that case were described as lowered instead of pulled out, but in this case, they were pulled out. In both cases, the pants were not completely removed. They were not pulled down. They were just pulled forward for a brief moment. And of course, that took place after the defendant was pat down and the officer looked inside of his pants, and then upon not finding the bag, then looked inside of his underwear. So there was multiple steps, and it wasn't just straight into the most extreme version of the search. Just briefly on the spit mask issue, the court properly exercised its discretion by conditioning defendant's presence at his trial on him wearing a spit mask and leg irons. The court held an evidentiary hearing, heard input from the part sergeant, and considered the factors that are laid out in the case law. The court had determined that defendant engaged in disruptive and dangerous behavior that posed a risk to everyone in the courtroom, and properly tailored the restraints that it required based on this behavior. So the leg irons were properly tailored based on the defendant's behavior of standing up, yelling at the judge, and then threatening the officers. And then the spitting, of course, was based on the fact.
In fact, at the trial, the defendant chose to appear virtually. Wasn't that ultimately what happened here?
That's correct, Your Honor. Yes, he chose to appear virtually after receiving several options from the judge. Just to add that the court did consider the prejudice that defendant would face based on the options it did give him, but in the end, he did choose to appear virtually. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Just briefly, Your Honors. First of all, I don't agree that the record shows the court below was equivocal about whether this was a strip search, but as Your Honor's questions indicated, even if it was, unless the court below decided it adversely, it's not properly before this court for appeal.
Well, if we accepted your argument, where would that leave us in terms of looking at the issue? Would we then still make a determination whether the search was reasonable, even if it was a strip search, whether it was reasonable under the circumstances?
So you'd apply the framework articulated by Hall and Mitchell to determine whether it complied with the requirements for a strip search conducted in public, which is that there be an extreme exigency. Which I think,
why did it not satisfy those requirements?
because what Hall says is that, and Mitchell say is that unless there's some imminent danger to the officers or others in the vicinity or the arrestee, a public strip search is categorically unreasonable. And there's no argument that there was any such danger here, and so the search here was unreasonable and therefore unconstitutional.
When counsel was explaining how the officers were concerned about the destruction of the contraband or whatever he was holding, I asked her, how was it going to be, how could it have been destroyed in those 2 blocks over under this, if he was handcuffed and as we asked our questions? I mean, is there something I was missing there? How could there have been a problem if they waited the 2 blocks to get to the police station?
I don't think you're missing anything, Your Honor. I think that it's totally implausible that the evidence could have been destroyed. No one has ever explained at any point why the evidence was at risk of destruction. And I'd also note, I think it's a distortion of Officer Lowe's testimony. He never says he has a concern about this defendant destroying evidence. He says generally that he searches people before transporting them. Not strip searches, just I think a regular search out of a generalized concern. That doesn't provide the particularized basis to perform a search in this case. If I just may very briefly discuss Butler, since my friend brought it up.
Your time's up.
Okay, thank you, Your Honor.
Question, though?
No, I was just curious about Butler.
Well, then, is that your
Okay,
question?
yeah, that is my question, that she says this is akin to Butler where it was pulled down
My
slightly.
colleague wants to hear about it.
Yeah.
Thank you, Your Honor. Yes, Butler is actually distinguishable in a pretty crucial way, which is that in Butler, one of the reasons this court gave for finding that no strip search occurred is the defendant's genitals were never exposed. They were slightly lowered at the back, and a bag was removed from the upper buttocks, is the language of the opinion. Here, of course, the key distinction is that Mr. Ortiz's genitals were exposed, and so I think that pretty easily explains why this is a strip search and that wasn't.
Thanks.
Thank you.
Thank you. Pepin versus Lascano.
Good afternoon, Your Honors. May it please the court. Jason Melesso for Appellant Diana Pepin. This is the only case that I've ever participated in or heard of from case law where a surgery occurred and no one agrees who performed the surgery.
Let me ask you, even if we assume that we don't know who performed the surgery, isn't it true that you still have to prove that some negligence occurred? Assuming they made their prima facie with their expert, don't you still have to come forward with some expert opinion that's not conclusory that there was negligence in this case, whoever performed it?
That's correct, Your Honor.
So what is the negligence in this case that your expert established, other than that there's a confusion about who performed the surgery?
Right. In the record, page 1692 is Dr. Horrell's affidavit. That's the plaintiff's affidavit. In the appellate brief, page 24, it's a very brief paragraph where Dr. Horrell says, I disagree with the conclusions of defendant's experts, lists their names, that Mrs. Pepin's current disability is a result of the original OCD condition or defendant's surgery merely failed. Defendant's surgery removed a significant but unknown amount of bone and cartilage. This is evidence of finding by Dr. Kosachuk, who did the second procedure, correct, and he cites the MRI procedure. The question is how much bone was removed. I mean, that's the issue in this case. And the defendants themselves can't answer that question. So how do their experts answer that? And, you know, at trial, although it's not available to me for summary judgment motion, at trial, I could put Dr. Kosachuk on the stand and he can testify as to what he found when he went in to do the second surgery and correct it. Right now, the 2 people with the best knowledge, Dr. Lascano and Dr. Francini, both say, I didn't do the surgery. And therefore, plaintiff is now deprived of that evidence. You know, I have an opportunity in any medical malpractice case to ask the defendant what
Your expert still has to come forward with an affirmative opinion that negligence occurred and these injuries were caused by this negligence. This is what happened.
Right. He would say, hypothetically, because no one else can disprove it, that if you remove too much tissue, if you remove too much bone, these types of injuries can occur.
Did he say that?
But there was an operative report from this surgery.
There is an operative report that's lacking in many ways. He actually my expert actually testifies inadequate.
Yes, he says it's not specific enough, but there is something in the operative report that will deal with some of these questions.
Two, we don't know that the operative report is accurate anyway, because Dr. Lascano testified, yeah, I signed it, but I didn't read it, I didn't perform the procedure. I mean, who's going to testify that that operative report is actually accurate? The defendants can't say anything about what they did. And I think it's unfair now to make me throw my cards on the table and marshal my evidence when the defendants themselves can't actually say what occurred during their own surgery. And that's affect what's happening here. It's unfair to make the plaintiff now come forward. I mean, they've got 3 experts saying, yeah, based on this, based on the operative report that we don't even know is accurate, there was a malpractice here. What is their opinions based on?
Thank you.
Thank you.
Good afternoon. May it please the court, Michelle Levin for Dr. Lascano. The only issue here was whether the surgery of September 13, 2011 was appropriately performed. Regardless of who did the surgery, it's not a material issue if it was appropriately performed. I want to take one diversion here, and that is in Dr. Franchini's brief. He says that if the first party action gets reinstated by this court, that the third party action should remain dismissed. And I did not have an opportunity to address it in my brief because it was for the first time coming in the respondent's brief, but I just want to point out that it was never raised below. It was never an issue decided by the court below. It's an improper issue for this appeal, and it really has no merit. Dr. Franchini's motion for summary judgment was that the surgery was done appropriately. I did not have to oppose it. We agree with that. He never established prima facie who did the surgery. That issue was not resolved by the court. So if for some reason this complaint gets reinstated, the third party complaint must also be reinstated. Notwithstanding, I believe that the decision below needs to be affirmed.
Why isn't plaintiff's expert sufficient to raise an issue of fact as to negligence?
So the plaintiff's expert, Dr. Hall's affirmation, doesn't raise an issue because of really 4 reasons. First of all, it's in improper form. It's not in the form of an affidavit under CPLR 2106. Second of all, Dr. Hall, what he does is he says there's missing information, but the information from the operative report, but it's contradicted by the record because it's in somewhere else in the record, or because the missing information that he identifies is not material because it's not connected to a departure from the standard of care. And in certain respects, he doesn't address many of the assertions that were raised by my expert, Dr. Larson. Now, I'm going to go through, for example, he says, we don't know the location of the drilling. But yes, we do know the location of the drilling because the OCD got smaller, confirmed by MRI, confirmed by Dr. Kosachuk's operative report. It went from a 1.4 to a 1 centimeter OCD. So we know where the drilling took place. We know that it got better. It actually got smaller. And then again, after Dr. Kosachuk's exam, it went down to 0.7 centimeters.
Is your prima facie showing dependent on the operative report? Did your expert need to rely on that operative report for a factual predicate for his expert opinion?
The operative report was only one piece of the information that he relied upon. He relied upon the preoperative records, the preoperative MRIs, the operative records, the operative report, the postoperative course, the postoperative MRI, Dr. Kosachuk's operative report, and also an independent medical examination that he conducted. And so the prima facie, this is all information that is reliable, professionally reliable. This is the type of information that experts rely on in rendering opinions.
Normally, we know who performed a surgery, so we have some confidence in the reliability of the operative report.
I agree, but the cases are dismissed all the time, and there's not testimony about every single entry in a record. The experts rely on entries made in the record without testimony, and that is sufficient. That's the standard for a prima facie showing, is that it's the type of information that an expert will rely on. It's professionally reliable. And if I could just say, going back to Dr. Hall's affirmation, quite critically on proximate cause, he actually says, well, the OCD didn't, our argument was that the OCD didn't respond to treatment, which was evidenced by the subsequent doctor. He says, no, it was new damage. That's contradicted by the record. There's no evidence that we caused new damage during the surgery. The Dr. Kosachuk says it still showed an OCD. Dr. Kosachuk says residual OCD. In his operative report, he says OCD and measures it and says it's 1 centimeter. There is no new damage. And in terms of proximately causing all of her ankle pain, the plaintiff testified all of these ankle symptoms pre-existed.
What about the allegation about loss of bone cartilage?
The question had to do, he said that the articular cartilage, there's no mention of the articular cartilage in the operative report. However, he doesn't connect it to a departure, and there's nothing in the record to say there was anything wrong with the articular cartilage. In other words, it's just a completely speculative theory. There's nothing in the MRI or in the subsequent operative report that says anything about articular cartilage, nor does he say that it's a departure. He doesn't connect it to a departure.
Thank you.
Thank you.
Good afternoon. If it may please the court, I'm Edward Nicholson for Dr. DeBello and the New York Foot Care Practice. I would just ask that the court affirm the lower court's dismissal of this action, in particular as to Dr. DeBello, as he had absolutely no responsibility in this action as claimed by plaintiff to supervise either Dr. Franchini or Dr. Lascano, regardless of who performed the subject surgery. Both of these doctors were board certified and they were capable and to undertake this surgery.
Would they be vicariously liable for Dr. Lascano because he was I believe he was an employee of the New York Foot Care Services?
Yes, Dr. DeBello and the practice would be vicarious, and that's the entire premise as to why he's in this action.
So the only way Dr. Bello gets dismissed is if the whole case gets dismissed, or the case against Lascano gets dismissed.
Well, we had...
One is tied in with the other with the vicarious liability.
Yes, and Dr. DeBello did not treat the patient either preoperatively or during the surgery, but he did see the patient postoperatively, and we've submitted an expert affirmation indicating that his postoperative care and treatment was entirely proper, and the lower court just did not get to that point of our motion papers, as they found that point obviously to be moot, finding that Dr. Lascano complied with the standard of care and that plaintiff failed to refute his prima facie showing. I don't want to reiterate everything that my co-counsel just said, other than to say that plaintiff's experts' opinions were conclusory, and just reiterate that there were objective radiological studies, the preoperative MRI and then the postoperative MRI, that plaintiff's expert could have relied upon to say that the surgical incision or the drilling was in an improper place. Other than that, I'm going to just rest on my papers.
Thank you.
Good afternoon, Your Honors. Greg Friedman for Dr. Franchini. We've addressed the medical evidence in detail. I'm not going to rehash any of it here. I just want to reiterate, plaintiff has no direct claim against us, and the one party, that third party that's in, Dr. Lascano, did not oppose our motion for summary judgment. They abandoned the claim. So no matter how you look at it, we are out of the case. The only thing I would touch upon is that nobody, either in opposing summary judgment or on appeal, has or could make any argument that there's vicarious liability for anybody with respect to Dr. Franchini.
You did nonetheless put in your own expert affidavit on the merits, correct?
Correct. I think we really had no choice. It would be crazy not to. And obviously, as far as the substance of the claims goes, we're all in alignment. This is really just a procedural matter where there's no direct claim against us, and there's no longer a third-party claim against us, and that's really the only point that I feel I need to make here today. If there are no questions, I'm happy to rest on the brief.
Thank you very much.
Thank you.
2497 Realty versus Fortes.
Good afternoon, Your Honors. May it please the Court, my name is Stephen Kaplan from Kaplan Levinson, representing the defendant appellants. This is a simple breach of contract claim. The dispute centers on the distribution of $1.5 million of proceeds that was paid by Exxon with the owner of an adjacent piece of property that they paid pursuant to a settlement agreement resulting from a petroleum spill on that property, which leaked onto the subject property.
So, not to cut you off, but this particular motion that's on appeal here is whether or not the individual defendants should be in this case or not, right?
That is correct, Your Honor. And the reason I started by saying that this is a breach of contract case is because I think the first thing we should look at is who the contract is between.
And it's not it's not the individual defendants.
The individual defendants are not parties to the contract. I don't think that that's seriously in dispute.
So was there any claims that you could find in either the complaint or the affidavit in opposition put in by the plaintiffs that made claims against your individual defendants as to why there should be a piercing of the corporate veil?
No.
Why is that?
So this was a 3211 motion,
Right.
Your Honor.
The judge, I know, allowed in a little bit more.
Right. Justice Ostrager sort of effectively converted it to a 32.
But he never formally
He never did. What he did was after the motion was fully briefed. So the complaint, the operative complaint, makes no allegations of alter ego liability or veil piercing. We moved to dismiss the individual defendants out on that basis, in addition to the fact that all of the other claims, the 6 other causes of action, beyond the breach of contract case, are not only duplicative, identically duplicative of the breach of contract claim, but that the individual defendants could not possibly be responsible for them.
Your position, though, is that we should only look at the complaint because it is a motion to dismiss and it's never been converted. Is that your position on appeal?
I apologize. I didn't hear.
That we should only look at the complaint and any affidavits in support because we are looking at this as a motion to dismiss. It hasn't been converted.
No, that's not my position. My position is that Justice Ostrager did something that was a little bit unique by
We should look
not
at all of
converting
it?
the motion. I think he should have either converted it or decided on the papers.
What do you think
the-
we should do?
Pardon me?
What do you think we should do?
I'm happy to have you handle it either way, and I'll tell you that even with the supplemented record, in no way did either the plaintiff argue or support with evidence the 2-prong test to pierce the corporate veil, nor did Justice Ostrager even address it. And that would really only relate to the breach of contract claim. I'm going to get to if I have time, I'm going to get to the duplicative nature of all of the other claims. But there's a 2-part test. It's been a long-standing principle. There's the complete domination prong, and then there's the fraud wrongdoing prong.
And you need both, right?
And you need both. And I'll do the easy part first. No one argued, no one alleged, and there is no evidence of the fraud part, nor did Justice Ostrager address it at all or explain it. The first part about complete domination, there's a 9-part test that is well established in this and other courts in this state that you have to satisfy it. It's not that you have to satisfy all, it's an analysis where the court looks and sort of weighs it out. In this case, there were only 2 of the 9 prongs addressed. One of them was failure to adhere to corporate formalities. These are both, and this is undisputed, single-member, single-asset, non-operating entities that owned an interest in an LLC that owned the real estate at issue. So there are they didn't maintain separate offices because that's, and I'll get to that, that's actually a second prong. The first prong was that there were no meetings of the members. Well, they're single-member entities. People don't have meetings with themselves. There were no bylaws. LLCs don't have bylaws. Corporations have bylaws. There were no minutes or resolutions arising from meetings that didn't take place because there are no meetings with one person. There was no corporate resolutions, same thing. The second prong that was addressed was, well, you didn't have separate offices. And I don't think that any single member, single asset, non-operating
It's kind of like when you
LLC has its own office.
like a single purpose entity. They were created just to have an interest holding the property, and that was their whole reason for being.
That's correct. There were absolutely no operations, and there was only, like I said, one member, one manager. So to say that one person controlled the entity, which was something that the plaintiff argued both below and before this court, that, oh, well, these people controlled those entities. Well, yes, of course.
Is there any allegation at all that the corporate form was used to commit a fraud somehow in this case in terms of withholding the money?
It hasn't been alleged. There's no evidence of it, and it wasn't discussed. I would challenge my adversary to go through the record and point out whether it's in the complaint where it says that the corporate form was used to commit a fraud. This was everything, if you read in this complaint, and everything that's really in the affidavits and the motion papers and everything that's in this record is that the plaintiff says that the two corporate defendants, the LLC defendants that are parties to the contract, owe plaintiff money, and you didn't pay it to me. That's what this case is. It's a one-count breach of contract claim against the party between the parties to the contract that is ripe for adjudication. The claim where you say,
Time on rebuttal.
thank you, Your Honor.
Good afternoon, Your Honors. My name is Lawrence Patinsky, Rosenberg and Patinsky for the plaintiff and the respondent.
So, counsel.
I was originally going to say I'm resting on the brief, but
fraud to support piercing the corporate veil.
Your Honor, the answer to that is no. The complaint does not have the specific allegations of fraud.
Isn't that fatal?
It's not fatal, Your Honor, because when the amended complaint was served, there had not been discovery, and what the Judge Ostrager properly did was said, wait a second, you can go ahead and do some extra discovery, submit some supplemental affidavits, and I will consider it in totality.
Is that allowed procedurally if the case has not been converted to a motion for some? We don't have a conversion to a motion for summary judgment here. So what we have is a motion to dismiss. And a motion to dismiss, the court's supposed to solely look at the pleadings and affidavits in support, not to order further discovery. So aren't we limited to that in terms of our ascertaining whether there are sufficient allegations to pierce the corporate veil?
So my answer is no, Your Honor, for two reasons. One, because Justice Ostrager did do what he did and let us submit those papers to the court. And while he didn't convert it to summary judgment, and he left it as a motion to dismiss, on a motion to dismiss, the lower court, and I would say Your Honors, must assume and take all the facts and most favorable to the plaintiff.
Okay, let me ask something. Let's say we allow all the discovery to come in and consider that as part of our decision. What came out in the discovery that supports your allegations of fraud?
What came out, Your Honor, was the additional papers from the client that said that he had only been dealing with these individuals. We do know they...
Isn't that always the case in every claim against a corporation? A corporation can only act through individuals.
That is correct, but I want to point out that in the First Amendment at Record 62, it even defines the entities individually as Mr. Abad and Mr. Fuertes. So the indications from the documents below create enough of an issue. Now, I know it's not an issue of fact determination.
How does that go to fraud? The fact that they may have been involved in running the corporation, that they may have made decisions for the corporation, even that they dominated the corporation, would not be enough under the current state of the law to pierce the corporate veil. There has to be some evidence that that form was used to commit a fraud. So what evidence came out in discovery that supports the claim that the corporate form was used somehow to commit a fraud in terms of plaintiff not being paid for what it was due under the contract?
The evidence that came out in the lower court or as part of the supplemental was that Mr. Abad and Mr. Fuertes, more specifically Mr. Abad, basically used his entity to take control of the ExxonMobil, receive the money, and then not disclose it, share it, or pay it under the contract.
Why wasn't that? Go ahead.
I'm sorry. I mean, isn't that a standard breach of contract cause of action, and your contract is not with the individuals?
Well, it is, Your Honor, and that's even to a certain extent that the individuals then should be included because they use their entities and instrumentality of not complying with the contract. In other words,
Right, but that's never been enough under our law. To say you have a breach of contract against a corporation, and then you have a claim against the individuals because they caused the corporation to breach the contract, that's not enough for piercing the corporate veil. There has to be something more than that.
I agree with you, Honor. And the analysis that's been steered by the appellants that this is a pierce the corporate veil is not what was argued below, and that's not really what Justice Ostrager was deciding. There is no claim to pierce the corporate veil per se. What it is that all these defendants, basically the corporations and the entities, are jointly and severally, they all acted together.
Well, if you're not piercing the corporate veil, and clearly the contract or the agreement is with the corporations, not with the individuals, what other basis is holding individuals liable for contracts that they're not signatories to?
We're saying there's a direct claim on the breach of contract against Mr. Abad and Mr. Fuertes.
Why?
Well, if you look again at the documents, I don't mean to say it that way, but in the documents, the references are to Abad and Fuertes personally, and they're referenced throughout the documents. Now, I will concede that the signature lines are only in the names of the entities.
Is there anything in there that says they're assuming personal liability
No,
for
there's
these
not.
obligations?
No, there's not. I just point out again, this is a motion to dismiss. This was the second motion.
Or not? We don't know.
One never knows, I guess, is the way to say it. But as well as presented to the lower court, it was a motion to dismiss, and all inferences should be given as most favorable to the plaintiff. Thank you.
Your Honors, page 62 of the record is what my colleague was referring to, where that is the First Amendment. That is the contract that we're referring to. And it refers to 145th Street Property Investor LLC, and it's a defined term as ABAD. Same thing with 2497 Partner LLC is a defined term as Fuertes. That could have said pineapple and ping pong. They're just defined terms. That does not mean that the individuals are being substituted in for the corporate entities. I don't find that to be really a good faith argument. With regard to the other claims, this court has held, and it's been, it doesn't require that much discussion to the idea that you can't take a simple breach of contract claim and turn it into a fraud in the inducement claim by saying you didn't intend to comply. You can't say you had a fiduciary duty to comply with the contract, so you breached the fiduciary duty. You can't say you didn't pay me money you owe me under a contract, so you've converted the money. You can't say that you didn't pay me money under a contract, so I'm entitled to an accounting. That's what all of the other counts are. And although the motion was for 3211 against the individual defendants, we did brief both in the lower court and in this court.
Why would we consider anything other than that? Since the only appellants before us are the individual defendants, why would we go beyond that?
I would suggest that this court has enormous power to search the record and make decisions that it believes is correct.
Usually it's to search the record when that party is actually before the court as an appellant. The corporate defendants are not before the court as even an appellant. So I don't know how we'd search the record as to them.
My understanding, Your Honor, is that the court can search the record.
Do whatever we want.
You can only search the
I was going to
record.
say that, but I didn't want it to sound weird.
You can only search the record on a summary judgment motion. There's no such thing as searching the record on a 3211 motion.
Fair
So
enough.
part of the reason that we've been put into this weird place is because of this hybrid 3211A7 augmented by evidence. So I don't think we have to worry about searching the record because it's only authorized under 3212B.
Agreed, and I guess we don't have to repeat that this was
Thank
sort of
you.
a hybrid situation.
Thank
I
you
thank
very
you,
much.
Your Honors, for their time.
Jenkins versus Gina B.
May it please the Court, Lorena Novotnik of Mental Hygiene Legal Service for the appellant respondent, Gina B. Mental Hygiene Law Article 81 is unequivocal. A hearing on guardianship must be held in the presence of the alleged incapacitated person, the AIP, and if the AIP is opposed to the guardianship, then the court shall appoint counsel to represent them. The trial court failed here in both respects, and it stripped Gina B of the right to make decisions about her own life without ever meeting her or anyone else who represented her interests. Indeed, no one at all spoke on behalf of Gina B at the hearing on Gina B's guardianship. I'll address each of these due process violations in turn, and also the statutory due process violations that stand behind them as a cascade of violations.
She had indicated the proposed AIP that she was going to attempt to appear virtually, right? She said she was going to go to the library and try to get a connection to get in, and then changed her mind or wasn't able to get in, or what happened the day of the hearing? Was she even able to hear anything? Was there any contact with her?
Well, that's the exact problem, Your Honor, is that we don't know. So 8111D states that the order shall set forward the factual basis for proceeding in the AIP's absence if the court has statutory authorization to do so, which it didn't have here. But what we have instead in this order is that Gina B, having initially stated that she would appear but changed her mind afterwards. How could the court possibly have known she'd changed her mind if they never spoke with her? So we have no sort of understanding of what happened because it's not recorded in the order.
And so the judge did not state any other reason why she decided it would be appropriate to appear, to continue, notwithstanding the AIP's non-appearance.
That's exactly right. Everything that we have is after the fact, including...
Why was it inappropriate for the court to rely on the representation of the court evaluator that he had made a determination that she had stated that she didn't want to be represented by counsel, and that he thought that was acceptable?
So it's inappropriate for a couple of reasons, beginning with the fact that the court evaluator is not the court. The court evaluator is essentially an independent contractor. So the court can't outsource its responsibilities, particularly something so important as understanding whether a waiver of counsel is knowing, to someone that, per the statute, doesn't even have to have a law degree. It just doesn't make any sense.
And as you said, the statute actually is written to say that that the court shall have her appear or him appear, the AIP, and that we don't have too much playing around with what the court shall do.
That's exactly right. So if you look at Wogelt, for example, what the court says there is that appointment of counsel is mandatory where an AIP is contesting the appointment, and the court should have appointed counsel as soon as it became apparent that the AIP was contesting. And that's what we had here. You know, the court evaluator has the right to be incorrect in what he shares with the court. It's the court's responsibility to make an independent assessment of that. So here the court evaluator incorrectly said, she's appointing counsel, but she seems, you know, she's opposing the appointment of counsel, but she seems capable of representing herself. The court should have looked at that and said, that doesn't make any sense. Because how can somebody have the capacity to refuse the appointment of counsel in a proceeding where they can lose such important rights as the right to contract, the right to decide where they live, and yet not have capacity to make those decisions themselves? And we have competing ideas here about Gina B's capacity, and that's exactly why the statute is written, that the appointment of counsel in this situation is mandatory.
I want to go back, if I can. What, if any, attempts did the court make to attempt to bring the alleged AIP to court for the hearing?
We have no idea. Again, all we have in the order here is that Gina B, you know, having initially stated she would appear, but having changed her mind afterwards. That's it. That's the sum total of the record on Gina B's appearance.
So your request here today is asking us to send this back to start all over again. What would happen if we grant, we agree with your position? What is the remedy that you are asking us to grant?
So the petition doesn't get dissolved. It goes back to the procedural puzzle. The petition doesn't get dissolved. It's not like we're starting from scratch. What we're asking for is reversing and remanding for a hearing where she can be present and represented by counsel.
So right now, over 2 years, she's been under a temporary guardianship.
Oh, no, I'm sorry. Please continue.
No, I thought she was under a temporary guardianship for 3 years with New York Foundation of Senior Citizens. And they wanted expanded powers, and that's how this all started. She got counsel, and this is how. So you're saying we send it back, and you said no. Tell me what needs to be corrected.
I'm sorry to interrupt you. What I'm specifically reacting to is the characterization of it being a temporary guardianship. The temporary guardianship means something specific in the statute, where the court can act in a protective fashion. If we haven't had a guardianship hearing, somebody's got a warrant of eviction on their door, they're going to be evicted tomorrow. We need somebody in place right now. What we have here is a 3-year-long guardianship, which anyone who survived law school can tell you is not super temporary. 3 years is a long time to have these rights removed from you. So it is a limited term guardianship in that it's not indefinite, but it's certainly not temporary, not by any stretch of the imagination.
Okay. So just could you finish up what you were saying with regard to the procedure?
Yes, absolutely.
So Judge Kapnick's point about, okay, where do we go from here?
So we go back for a hearing where this gets redone. We do a redo here. She gets counsel. She has the opportunity to be present. And if after that there is a finding that, she needs a guardianship, that's what happens.
So
we're
they
saying
can,
that
the judge could potentially appoint the same guardian or appoint somebody else, but there has to be, what you're saying is there has to be a hearing with with counsel appointed and with the proposed AIP, either virtually or somewhere there, so the judge has an opportunity to see her and interact with her in some way.
That's absolutely right. And I want to make clear that we feel that we've established sufficient facts that the guardianship is either not necessary or not tailored, limited to the harms that are contemplated. So I'm not saying that she's going to go back, she's definitely going to get a guardian. What I'm saying is that that is a potential outcome, yes.
We're not deciding those.
Right.
We're just deciding whether or not she was afforded due process in terms of the guardian being appointed. So has the guardian been acting all this time, up till right now? Like the guardian's been performing the guardian roles in terms of the issues that did get raised in terms of the initial petition?
May I briefly respond?
Yes.
Yeah.
So she has had a guardian. The extent to which her guardian has been helpful, and this isn't before the court, so I don't want to get too far.
I know
afield
it's
into
outside the record, but yes.
Well, to the extent they've been helpful, I think that's dubious. She has lost her homes, so she is to the extent that the guardian actually did anything.
Lost what?
She lost her apartment. So to the extent the guardian has actually
living in another apartment in that complex?
no.
She lost her apartment.
She lost her apartment. So the extent that guardian has actually done anything at all or been helpful to her in any way is suspect.
Where is she living?
And again, this is outside the record, so I don't want to get too far afield, but it's my understanding that she is living in a shelter.
Thank you.
Tahir Sadria, appearing on behalf of the Commissioner of Social Services. I just wanted to address one thing that was raised previously. The record does show that there were telephone calls made by the court evaluator and by the Adult Protective Services caseworker at the time of the hearing, and that somebody did reach her and attempt to get her, get the appellant to appear at the hearing either.
So don't we have a case right on point where we said that more than an attempt has to be made to have the allegedly incapacitated person present at the hearing? Isn't that what we held in Matter of Banks?
So I'm sorry if I
Matter of Banks.
Matter of Banks. I'm not sure if I'm remembering the exact one, but I think that there are cases that show that an alleged incapacitated person can refuse to appear and can refuse to be appointed counsel.
Here that there wasn't any communication directly between the court and the alleged incapacitated person, and it was just the first time that it was on. It wasn't that it had been on numerous times and she hadn't appeared. It was the very first time that it was on, and the court had never directly communicated with her, had not appointed counsel for her, had not had a discussion with her about whether counsel should be appointed. Wasn't that too quick?
Well, I mean, I think that it's...
Considering what's at stake in this case?
Right. I mean, I think that there's two issues. There is the question of whether or not it was error not to have an adjournment so that she could appear, because I mean she could not the court could not at that hearing speak with her because she was refusing to appear. Even though they had contacted her, she was still refusing to appear.
Isn't counsel correct that the mental hygiene law specifically states in Article 81 that the court shall permit or allow the AIP to be present in some format, whether in person or virtually, at this hearing?
Certainly, the mental hygiene law states that the alleged incapacitated person shall appear. But at the same time, it does also, the mental hygiene law does also recognize situations where the alleged incapacitated person will not appear.
But wasn't part of, I thought, the concern was that there had been nothing put on the record for us to understand why the court went on without her.
I mean, I think I think that this kind of leads to the other point is that this is not an appeal from the order of guardianship. It is a motion to vacate, and so, you know, on the record on the motion to vacate, I mean, there's evidence regarding the efforts that were made to contact the appellant, and I think it's also on a motion to vacate, it is the appellant's, as the movant, her obligation to make a showing of entitlement to vacater. I mean, and she brought this motion as a motion to vacate on the basis of excusable default under CPLR 5015A, and she has not made any kind of showing of a reasonable excuse for her failure to appear or of a meritorious defense. I mean, there is normally, you would expect that there would be an affirmation where she said—
This isn't a typical case. Don't we have broader concerns in these mental hygiene proceedings and the particular dictates of a mental hygiene proceeding in terms of, and which our court has discussed before, the particular interest in having the allegedly incapacitated person present at the hearing? This isn't like a typical default in a civil litigation where there's like a money judgment being entered against somebody.
It is true that it is not a typical case, but it is still a case where this is being brought as a motion to vacate a default judgment.
If I may, you know what? Let me let you finish that sentence. Go ahead,
Thank you.
please.
And certainly the court has inherent powers to vacate a default judgment on a showing that there has been like a fundamental violation of due process, but there hasn't been a showing here.
Let's talk about that,
Okay.
because the AIP contested the appointment of counsel.
Yes.
And the statute requires the appointment of counsel when an AIP contests the appointment of an attorney, correct?
So it's interesting because—
No. The statute is very clear, 81.10C. That's a yes or no. It's very clear. The court shall. Am I right about that?
The statute says that, but the statute also—
Let's go further. So the statute says that. We can agree upon that. So we know that the court evaluator, indicated that they believed, the person had the wherewithal to, waive counsel. My question is, what, if any, determination did the court make to satisfy itself that the AIP truly, and I'm paraphrasing, had the wherewithal to make an informed decision?
The record doesn't show that there was an additional that there was conversation directly between the court and the alleged incapacitated person. The conversation, it appears, was with the court evaluator, and as to why
So we're just really taking
but I think
the court evaluator's word. I mean, there was no independent inquiry to determine whether it was an informed decision to waive counsel.
Right. I mean, I think that again, I would come back to the point that this is a motion to vacate, and that it wouldn't have been difficult to put in a statement either by the alleged by appellant that she did not fully comprehend what the ramifications were of not having counsel appointed, or that from counsel stating that she had spoken with the appellant and she clearly didn't understand the ramifications of this. I mean, I think that there is a distinction between what would be grounds for an appeal if it was a direct appeal, and what is ground, what is the showing necessary for a vacatur of a default judgment?
Thank you very much.
Thank you.
Forgive me. Just to touch on a couple of the points. First, all the attempts to contact Ms. B were stated in opposing counsel's affirmation upon information and belief. So there's actually nothing at all in the record. Second of all, Your Honor mentioned matter of Banks, also known as Gwendolyn R., which states that the first appearance, in that case, the respondent stated to her attorney that she was ill that day. First of all, she was represented by counsel at that hearing. And second of all, she stated to her counsel at that first appearance, I don't feel well, and the court went forward without her. And this court said that was inappropriate. They shouldn't have gone forward on her first appearance.
Let's say we agree with you, we vacate the order in judgment. Does that leave the woman just now her own, the master of her own domain, so to speak? She now no longer has any form of a guardian looking after her affairs upon the, if we were to grant your cross motion?
For the time being, until such time that they could arrange for a hearing to be held. If I might just briefly respond on that point in addition. So MHL 8123 has provisional remedies, including the appointment of a temporary guardian ahead of a hearing such as that, a full hearing on guardianship. So it's not as though there's no mechanism in place.
So if we were to grant your motion, you would go you could potentially, would it be you that would go immediately to request a temporary guardian pending the next step, whichever, since we would be sending it back for further proceedings?
It would be petitioner's burden to do that because
You wouldn't be doing that.
it wouldn't be me.
Petitioner's burden, yeah.
Ms. B does not want a guardian, but it would be petitioner's burden to request a temporary guardianship.
Thank you very much.
Thank you.